Notice of striking 174 notice filed by Jane Doe. Okay, so it's by Pixie's side. Of course, it's by Pixie's side. You know, our goat Andrew Brettler would never make such mistakes. Wait, what the fuck? They don't even know how to file a document? They don't even know how to file a document, dude. Fuck me, dude. Oh, man. Yeah. That's why I just right there. Hey, good luck. Plaintiff's notice of striking of DE. Once I almost read this as DEI 74. Oh my god. DE 174. Plaintiff Jane Doe, by and through her undersigned counsel, in accordance with the court's November 12th, 2025 order DE 175, hereby respectfully gives notice of the striking of docket entry 174 pertaining to a conventional submission of a USB drive plaintiff made without including the notice of conventional submission at the filing window. So this is specifically talking about a USB containing 2 audio clips of Destiny on my stream talking about the lawsuit, specifically in such a manner where he's trying to format shit. And apparently Pixie's team is trying to present this as evidence of them manipulating the information and creating fake information in order to win the lawsuit or some shit, okay? Just, if you think it sounds stupid, you are right. Okay, it is very retarded. Okay, it's still retarded. But yeah. Wait, so why do they need a striking? Whatever. And then response in opposition to motion. Okay, so this is by. Wait, who is this by? Oh, this is by Pixies. Okay, so this is Pixies. Another Pixie fucking motion response thing. Okay. Plaintiff Jane Doe, by and through her undersigned counsel, respectfully submits this response to defendant's motion for protective order. Oh, okay, so this is like another protective order, like, fucking request. And in support thereof states as follows. Introduction. Defendant's motion for protective order rests on a false narrative that omits key facts demonstrating plaintiff's good faith and defendant's obstruction. I think one of the arguments that Andrew Brettler has made before was that he said that I think what they're doing is like, if Pixie is going to be using bad faith attacks in order to obstruct the court process in regards to, oh yeah, well, this doesn't have the hash code. If it doesn't have the hash code, how do you know that this is like an authentic copy, right? Oh, how do you know any of this is authentic or anything like that, right? So basically, I think here, and this is my assumption. My assumption is that Andrew Brettler is just essentially trying to turn her own logic against her, right? So Andrew Brettler is trying to use Pixie's logic and use it against Pixie, okay? Basically, if you're gonna call us out for not having authentic shit, then we're gonna call you out for not having authentic shit because you also did not provide any kind of hash authentication or anything like that. Now, I don't know whether or not that has anything to do with this. I'm just assuming. I'm just assuming simply, based off of what I have figured out before. Okay. But yeah, that's just that's the shit. Okay. I can't imagine being a lawyer. Can you imagine being a lawyer? Like, this is such a scuffed ass. I can't imagine your entire career is just like completely predicated on making essays. Like, your entire career is making essays, bro. It's time to turn yourself in. Everything is lost. It's over for you, dude. It's over. Your entire career rests on making essays. Oh my god, how do you live with yourself? Anyway, it's okay. But yeah, good stuff, good memes. Okay. In reality, plaintiff diligently sought to coordinate both depositions, offered multiple reasonable in-person dates. Oh, this is about the deposition. Okay, and properly noticed defendant's deposition for November 6, 2025. A deposition is a court hearing in which cross-examination is allowed by one particular side to the other person or something, right? So if it's Pixie's deposition against Destiny, basically Pixie's lawyers are cross-examining and questioning Destiny. If Destiny is doing a deposition against Pixie, Destiny is having his lawyers cross-examine and question Pixie, right? So that is basically what a deposition is, I think. And what that is like, yeah. I think they have assistants that do a lot of that now. Fired them. What the fuck? Worst assistants ever? Hello? Um, Defendant refused each of the multiple offered dates for plaintiff's deposition despite counsel's availability, unilaterally and improperly noticed her deposition for a date he knew she could not attend, and then refused to appear for his own properly noticed deposition unless plaintiff capitulated. Right. Okay. So Pixie doesn't show up for her own fucking deposition. And in addition, has is basically saying, "Oh my God, they're being bad faith. They're not trying to do this and that." But you know what? Fuck Pixie. Okay, it's okay. How fast would you get this case dropped if you were Steven's lawyer? What do you mean dropped? What do you mean by that? You mean like give up on the case, or do you mean like, um, yeah? What is it exactly that you mean? Because if it's giving up on the case, probably not. If it's like how fast I can work my way through in order to get the case dropped, then I don't know. Like I don't know what I'm supposed to say. Like win the case? I don't know. I don't know. I'm not sure. TBH. In order to avoid the unnecessary burden of missing her classes and the expense of traveling to Miami twice. The defendant accepts day one, okay? Easy peasy day one, okay? Just don't ask me how I did it. Just know that I did it, okay? Instead, the defendant's only concern and the only reason for this discovered dispute is that one of defendant's 5 attorneys, out-of-state counsel Mr. Bretler, suddenly and disingenuously claimed that he would be burdened by having to travel to Miami twice. Okay. Moreover, and contrary to so this is just a bunch of whining, right? Moreover, and contrary to defendant's assertion, plaintiff's counsel never represented that they are available to depose defendant on November 24 or 25, nor are they available since plaintiff's lead counsel, Ms. Peters, has prior commitments outside of Florida, and co-counsel, Mr. Garcia, cannot take the deposition due to health constraints. Dude. Bro, look at my lawyer's dog. Defendant has not and cannot show good cause for his scheduling shenanigans. Oh my God. Can you imagine writing scheduling shenanigans in a fucking court motion? I like, is that even admissible legal language? What happened now? It's just stupid, like, fucking whining on why Pixie didn't show up for her own fucking deposition. Dude, fuck me, dude. Unilaterally scheduling plaintiff's deposition for an unavailable date and then refusing to appear at his own agreed to deposition is now insisting that the deposition to be held consecutively. I feel bad for Brett? Well, don't. You don't need to feel bad for Brett. Because chances are Andrew Bretler is working on other cases right now. He is, like, he just views this as, like, quick money. Can the lawyer take on multiple cases? I'm pretty sure a lawyer can take on multiple cases, right? Here's a link to the case Pixie's legal team reference. So crazy different than the fact pattern she has. Hey, yo. Okay, okay. I probably won't read that. I'll just take you at your word, okay? Look, if it's scuffed, it's scuffed, okay? Defendant has not and cannot show good cause for his scheduling shenanigans. Unilaterally scheduling plaintiff's deposition for an unavailable date and then refusing to appear at his own agreed-to deposition, and now insisting that the depositions be held consecutively. The record demonstrates that defendant's purported burden is disingenuous, and even assuming it is not, no authority supports prioritizing the convenience of out-of-state counsel over that of Miami-based parties and the local counsel in a Miami forum. Defendant's conduct constitutes discovery abuse, not cooperation. The court should deny defendant's motion. Relevant facts. 1. Defendant's deposition date was agreed to and noticed. On September 17 and 19, 2025, plaintiff's counsel requested defendant's available dates for deposition. Defendant's counsel responded on September 22nd that defendant was available the first week of November, and on September 26th confirmed November 6, 2025 for his deposition. Plaintiff served the formal notice of deposition for that date, which defendant's counsel acknowledged, stating, "We will calendar Mr. Brunel's deposition on November 6th. Thus, by September 29th, defendant's deposition date had been mutually agreed, noticed, and calendared. It was not until 1 month later, on October 30, that defendant's counsel first indicated that defendant would not appear and improperly conditioned his appearance on plaintiff's appearance. And this counsel responded on September 22nd. Wait, but Pixie not showing up is like before, right? Is before this shit? No? Wait, hold on. Oh, plaintiff informed defendant that she was not available. Okay. Plaintiff informed defendant that she was not available in Miami on the unilaterally noticed November 3rd date due to her class schedule at her school in Illinois, because it would necessitate missing 3 full days of classes. Wait, so she missed the first deposition first, right? Like, plaintiff diligently sought offering reasonable the date defendant's counsel proposed and confirmed. Defendant refused each of the multiple offer dates for plaintiff's deposition despite counsel's availability and blah, 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 blah. Okay. He made no effort to accommodate. Plaintiff informed defendant that she was not available in Miami on the unilaterally noticed November 3rd date due to her class because it would necessitate missing 3 full days of classes due to travel time. Since plaintiff was planning on being in Miami for her school's Thanksgiving break, she offered the dates in order to avoid a burden. Especially disregarded the inconvenience and effect on plaintiff. The only reason for it is that one of defendant's 5 attorneys suddenly disingenuously claimed he would be having burden to having to travel Miami twice. Moreover, and contrary to defendant's assertion, plaintiff's counsel never represented that they are. This is so silly. So the stated reasoning on why these dates would not work out is that she would be attending classes, right? But think about this: if you're gonna sue someone and you're gonna like fucking ruin her life, ruin his life. Sorry, I forgot that Stephen was in fact a black man. Okay, sorry, a black woman. Fuck me. um yeah, like if you're trying to ruin someone's life, obviously I don't think you should have the privilege to like just simply go to school and take classes and get your degree, right? Like fuck that shit. If you're going to be going to college, then you should take a break from college, right? You should take a break from college. You shouldn't be focusing on this and that. I think you should take a break from college to focus on the lawsuit. Otherwise, like, what is the point, right? Defendant has not and cannot show good cause for scheduling. Okay, all right, gotcha. 2. Plaintiff's good faith efforts to schedule her own deposition. After defendant's deposition was confirmed, his counsel requested dates for plaintiff's deposition in Miami in October. Okay, we're definitely past October. Plaintiff's counsel informed defendant that because she was attending school in Illinois and based on her class schedule, she was not available in Miami in October. Instead, offered a date of November 21st in Miami. Okay. Defendant's counsel, Mr. Bretler, stated that he was unavailable on November 21st and again insisted on dates in October. Plaintiff, based on her class schedule and requirements governing class, then offered remote deposition dates of October 24, November 7, or 14, as well as additional in-person dates in Miami on November 24 or 25. On October 1st, Mr. Bretler rejected all these dates, again insisting on October dates in Miami. Oh, okay. So Pixie is asking for a remote, a remote hearing, right? Over Zoom. It's like a fucking Zoom hearing, but obviously that is unreasonable, given the fact that given the fact that like she's attending classes. Are you kidding me? Just go and travel and like fucking take a few days off, right? So yeah, no, this is just completely stupid right here.
A martini, shaken, not stirred.
GL with housing related stuff.
Zorb, thank you so much for your $20. I appreciate that. Thank you. You're very kind. Okay. Plaintiff's counsel, Mr. Garcia, responded that Mr. Bretler was apparently available on November 24 or 25, and explained that plaintiff was not available in Miami other than November 21, 24, or 25 due to currently residing in Illinois, and because any other in-person dates would necessitate missing 3 full days of classes. Again, it's kind of absurd to me that Pixie isn't even found in Miami anymore. That is absurd to me, just mainly because like you would probably expect you would reside in the same place that you're filing your court case in the district of Southern Florida, right? Like why the fuck would you even file a case in Florida in the first place if you're going to spend most of your time elsewhere, right? Like if you're going to spend most of your time elsewhere, why even file it in Florida? Why not just go with another fucking place? Yeah, I don't know. Like, she's trying to have her cake and eat it too. If I was going to school, right, I probably wouldn't be able to concentrate on school considering how there was like a fucking court case going on, right, in my life. Because I would be like fucking anxious as fuck, right? But somehow she's able to do it. I think that's kind of crazy to me. But whatever, you know. We love our queen, okay? BBD queen, let's go, woo! I don't know. It's just so stupid. But it's inconvenient for her. Yeah, it's just so stupid. It's like, oh my god. Yeah, I don't know. This entire shit is like completely fucked. Okay, Jesus. Um. Also, another thing you have to kind of keep in mind, is that when it comes to why is it that you're not doing school remote? I guess is a question that I would have. Like, why is it that you're not looking for some kind of special exemption from the school to take remote classes in Florida, so then you're able to attend court cases and court hearings in Florida? For me, I just don't get why. Like, there's just literally no point to having any kind of like fucking, oh well, wishy-washy whether or not you're going to be in Illinois or Florida. No, just fucking stay in Florida. Like, ask the dean or some shit about like fucking staying in Florida while going to school in Illinois or some shit, right? Like what's the point? It's just so, I don't know. It's just like this entire thing is so stupid. It's like, oh my god, I'm gonna miss my classes. What? Okay, dude. Who cares? All right. Plaintiff was not available to be deposed in Miami on November 3rd. Plaintiff was not available to be deposed in Miami on November 3rd because she had a full day of classes scheduled. That's so crazy. Dude, isn't a lawsuit supposed to take up your entire life? Isn't a lawsuit supposed to take up your entire life during the course of the lawsuit? I feel like whenever I go over someone, whenever someone is going through a lawsuit, like forget about school, forget about everything that's going on, right? Like what's the point of doing anything in your life right now if you're in the middle of a lawsuit? I just don't understand. There has to be something I'm not getting here. It's just so crazy to me. But yeah, it's good memes at least, I guess. I don't fucking know. For this reason, and based on her class schedule and requirements, she was not available or able to appear for a deposition since it would necessitated missing 3 full days of classes. Oh, boo-hoo. Boo-hoo, dude. People with depression miss like longer periods of classes. I'm sorry. I don't know why she's, what the fuck? Yo, that's crazy. What the fuck, dude?
Just a drink.
Oh
Mounty,
my
shaken, not
god.
stirred.
No snitchin'.
True. Yo, Mickey, thank you so much for 20 Australian. I appreciate that, buddy. Thank you. Dude, this is so stupid. Like, this is actually, like, the most regarded court case ever. What the fuck? Bro. True, I missed all my classes from my last semester, only showed up for exams. Dude, it's so crazy! Can you imagine? Can you imagine? This is like the opposite of like trying to justify to your professor that why you didn't turn in your homework. Excuse me, Samuel, why didn't you turn in your homework? I had a lawsuit that I had to go to. Oh, okay. I perfectly understand. Like, what the fuck? Also, another thing is like, um, what is? Oh, hey, why is it the case that you're there's no fucking I don't fucking know. Why why are you unable to uh I don't know, attend classes for last week? Oh, I had a lawsuit. Oh, understandable. Okay, yeah, that's more understandable. Okay, you can't treat it vice versa, and you go like, well, Mr. Judge, the reason why I couldn't show up for this is because, I had to attend classes. Like, what the, what the, nar, no. That's crazy. That's crazy. This is crazy energy. This is crazy energy right here. Can you imagine like you going up to your teacher or professor and you're like, can you, like, no, sorry, you going up to your dog and you're like, sorry that I brought the homework for you to eat late. I was busy taking school classes. Like, it's like it makes no sense. You know what I mean? Like, I don't. Okay, sorry. Okay, you didn't get that, but that's okay. Okay. Anyway, plaintiff was not available to the post. Additionally, traveling to Miami and oh my god, this is so crazy, dude. Additionally, traveling to Miami and back from her school is very expensive. Okay, hold on. I'm about to pull off the biggest eye roll of all time. Ugh. Okay, sorry. With round trip flights averaging $900. Now, the reason why this is ridiculous is because it's clear that more money has gone into this lawsuit overall as to make $900 minuscule, right? $900 is microscopic compared to the fucking money that you put into the lawsuit overall, right? The money that you have to spend on the lawyer, the money that you have to spend on all the court filing costs, the money that you have to spend on X and Y, unless you're doing pro bono, but you still have to spend money on a lot of things. So the fact that it's like $900 is, oh no, $900, woe be me. It's just like, fuck me. In order to avoid missing 3 days of classes and jeopardizing her academic standing, this is so stupid. Fuck her academic standing. Like, what is the point in doing it, like, having an academic stand? That means no, so stupid, dude. And to reduce the cost burden, plaintiff offered the dates of November 21, 24, or 25. Since she would be in Miami on those dates. Or alternatively, 3 remote deposition dates. Okay. Defendants claim, so she offers different dates where she can be in Miami. Okay. Defendants claim burden and expense is disingenuous. Defendant's narrative that he must take plaintiff's deposition during the same week as defendant's deposition to avoid unnecessary burden and expense is contradicted by the record. Okay. On September 26th, 29th, 30th, and October 1st, after defendant's deposition had been calendared for November 6th, okay, defendant's counsel repeatedly insisted that plaintiff provide dates for her deposition in October, showing no concern then about his unnecessary burden and expense. What? Wait, I don't get it. I don't get this point. Wait, oh, defendant's narrative that he must take plaintiff's deposition during the same week as defendant's deposition to avoid unnecessary burden and expense. Oh, okay. So they want to do the two depositions during the same week, right? Is that what Destiny wants? So Destiny wants the both of the depositions to be in the same fucking week, right? Is contradicted by the record. After that defendant's deposition has been calendared, defendant's counsel repeatedly insists that plaintiff provide dates for her deposition in October, showing no concern about his unnecessary burden and expense. Just yeah, but like maybe it's like maybe he doesn't have to worry about like unnecessary burden and expense during that period for whatever reason it is. Like who cares? He also showed no concern for plaintiff's unnecessary burden and expense in having to miss classes and travel to Miami to be deposed in October or on November 3rd in Miami. Well, who cares if she misses classes? Like you're really saying that professors aren't willing to like bend the rules a little bit, not willing to give you some degree of like fucking flexibility around like the shit that you're doing? Um because do you know what I remember? I just remember like I just remember that back when I was in college, professors would be really accommodating. Like professors are generally one of the nicer people you'll meet in life, right? Other than a caretaker or a doctor, right? Genuinely. Like even like some professors will be hard asses, but like they'll understand if you have to go for a fucking lawsuit. Like all of them will understand. Yeah, the closer to the holidays it is, the more expensive. Oh, so stupid. Showing no concern. He also showed no concern for plaintiff's unnecessary burden and expense. Okay. Then on October 2nd, out-of-date counsel Mr. Bretler suddenly expressed a newfound concern with his own burden of having to travel twice to Miami, and for the first time insisted that plaintiff's deposition be taken during the same weeks as defendants. Well, this kind of makes sense, right? Because if Andrew Bretler is a lawyer, his time is extremely valuable because Andrew, right, the lawyer, he's probably tackling multiple cases at the same time. Actually, are lawyers like allowed to tackle multiple cases at the same time in the same firm? Is that allowed to do? I'm pretty sure you're allowed to do that, right? But hold on, let me see. Oh, yeah. Okay, okay. Yes, lawyers routinely handle multiple cases at once and can even represent multiple clients in the same class under certain conditions, though there are limitations and ethical considerations about. Okay, yeah. So if you have Andrew Bretler constantly traveling back and to right from Miami and back and forth between New York and Miami and stuff like that, right? That might get in between Andrew Bretler and his other clients, right? What like why the hell would Andrew Bretler like fucking fuck over his other clients in case that he has other shit scheduled on these days, right? Like that would make no sense. Like this is just really stupid. If cost saving was genuine, defendant would have deposed plaintiff in Illinois on the proffered day of October 24. Immediately following the October 20. Is this like a remote deposition? Is that what they're saying? Okay, yeah. Moreover, Mr. Bretler had to be in Miami for another matter on November 4th, which is why he offered to agree to November 6th for defendant's deposition. Rescheduling defendant's deposition so that both depositions be taken the week of Thanksgiving would not actually minimize any burden inconvenience issues since Mr. Bretler still had to be in Miami the first week of November. Thus, defendant's claim of unnecessary burden is plainly disingenuous. Like, this is so stupid. Like, who gives a fuck about your fucking classes, bro? Like literally, who gives a flying fuck about your classes? Frankly, I don't think you should have the privilege of attending college while you're trying to ruin someone's life over a lawsuit. Like this is just so shameless to me, right? Like if anything, it should just like show how shameless this is. The fact that yeah, the fact that, oh yeah, you have to worry about this deposition, oh you have to worry about classes. Bro, dude, you focus on one thing in your life at a time. It's so crazy that this is just it's a concern that's actually being brought up. Oh my god. Defendant's unilateral scheduling was not in good faith. Ignoring plaintiff's stated unavailability and burden on October 3rd, Mr. Bretler insisted that plaintiff appear for her deposition in Miami on November 3rd. This date was convenient for Mr. Bretler because he had to be in Miami for another matter. Yes. Okay. Faced with Mr. Bretler's new demands, plaintiff's counsel once again explained that plaintiff was not available on November 3rd and that defendant's deposition had already been confirmed for November 6th and would not agree to rescheduling it. During the October 7th meet and confer, plaintiff's counsel explained the dates of November 24 or 25 had only been offered for plaintiff's deposition and not for defendant's deposition, because plaintiff's counsel were both not available in Miami on those days. Why are you not available in Miami? You are expected to live in the same place that the fucking lawsuit is being filed because you could appear in court any moment. Or you have shit to turn in and you can just simply appear. Why the fuck are you in Illinois? Dude, I can't believe this is a thing. This is so crazy to me. After counsel were unable to reach an agreement, Mr. Bretler noticed plaintiff's deposition for November 3rd, a date he knew she could not attend. Plaintiff immediately advised she would not appear for a deposition set on the date long known to be impossible. By refusing to calendar plaintiff's deposition for 24 or 25, defendant's counsel disregarded the unnecessary burden on plaintiff of having to miss 3 days of classes. Oh no, 3 days of classes. Oh no. Defendant threatened retaliation and refused to appear. On the eve of defendant's November 6th deposition, defendant's counsel announced that defendant will not appear for his deposition on November 6th unless plaintiff appeared on November 3rd, effectively holding his own testimony hostage to coerce compliance with his unjustified demands. Nice. So stupid. Defendant falsely asserts that plaintiff and her counsel represented that they are available for her defendant's deposition on November 24 or 25. Taka said Pixie for sure will win this and Destiny will get sanctioned for coercion. Okay, good luck. That they could not depose defendant on either date because plaintiff's counsel were not both available in Miami on those days, and thus they cannot agree to changing defendant's agreed deposition date. Ms. Peters has prior commitments outside of Florida, and co-counsel Mr. Garcia, recovering from medical procedures, limiting his speech, cannot conduct defendant's deposition, so he can attend to defend plaintiffs with Ms. Peters' remote assistance. For these reasons and in good faith, plaintiff's counsel offered those dates only for plaintiff's deposition, not for defendant's deposition. Plaintiff's counsel cannot be compelled to take defendant's deposition remotely, particularly when an agreed in-person date already existed. Mr. Garcia disclosed his medical constraints to the court and counsel during the April 4th, 2025 status conference, and again during the meet and confer, yet defendant's counsel remained unyielding and instead proceeded to unilaterally notice plaintiff's deposition for a date she was unavailable and engaged in meritless motion practice. Okay, there's just like fucking... There's just like date haggling. Like this is just what it is. Legal standard. Federal Rule of Civil Procedure 26C governs and provides that a court for good cause shown may make any order which justice requires to protect the party or person from annoyance, embarrassment, oppression, or undue burden or expense. The moving party carries the burden of showing good cause for the entry of a protective order. Good cause requires a specific demonstration facts to support the motion. Conclusory statements about need and harm are not sufficient. Although is tiny fucked how? Although good cause is the standard under Rule 26C, courts in the 11th Circuit have superimposed a somewhat more demanding balancing of interest approach to the rule. This requires the court to balance the parties' interests when deciding whether the discovery could be permitted. Defendant's motion for protective order should be denied. The federal rules and local rules require cooperation and mutual accommodation in discovery scheduling. Defendant's conduct unilaterally noticing an unavailable witness despite reasonable alternatives and conditioning. Unilaterally noticing an unavailable witness. Is this talking about Abby? Okay. So my question is, if this is talking about Abby, I'm pretty sure Abby is like dodging on purpose, right? Yeah. Abby is dodging on purpose. Despite reasonable alternatives. Yeah, she is. Despite reasonable alternatives and conditioning his own compliance on her attendance solely to account. No, that's Pixie. Oh, unavailable witness? But it says witness. It says witness, not plaintiff. If she was so distraught from this happening to her, wouldn't that take priority over missing a few classes? Yes. That would be Pixie's the... What? Okay. Violates both Rule 26 and the spirit of the rules of professional conduct. Courts consistently reject such sharp tactics. Magistrate Judge Torres squarely rejected the same behavior, finding that there was absolutely no justification for unilaterally. Yeah, she's technically a witness. Okay. All right. No, I get the point. Abby would not be necessary for this, right? I'm assuming so. Like, she isn't required to come, in that sense, right? At some point, you can be so incompetent that the judge gets mad at the competent counsel for not wiping the floor with them. 10D chess. What? Okay. Magistrate Judge Torres admonished counsel, noting this wastes the party's time and money as well as scarce judicial resources. True. Is disagreement over dates of deposition a normal thing? Is this a thing that happens? It's like disagreement over deposition dates. Is disagreement over deposition dates normal? Oh, yeah, no, it is common. Scheduling conflicts, professional courtesy, strategic delays. Okay, so strategic delays as in bad faith delays, right? Okay. Interesting. I think Kafka has told Destiny that this sort of pettiness is usually only seen in family law stuff. I wouldn't be surprised. It's how lawyers get to bill for more time. Come on. Well, true, but like there's no shortage of cases for lawyers to take on. Even if lawyers finish a case early, they are able to take on another case, right? And the more cases you take on, the more cases you win or lose, and the more cases you have on your record, right? Yeah, at the end of the day, if one case drags on for too long, sure, they're earning the money, but like, bro, that time could have been spent doing something else for other fucking cases that they could have spent to win other cases and take on more cases. It's just like, no, yeah, I don't know, it's stupid. She just blew it off. Wait, which deposition is the one that she didn't show up on? But it's not the lawyer representing the delays, it's the plaintiff. Sure. Right. Um, No, I think both sides have stated that they have had their own reasonings as to like um not showing up, right? Like to be fair, both sides have expressed like, oh yeah, I have a throat surgery, maybe I'm like healing from a medical procedure. I'm like busy doing something like this on some day or whatever. I don't know. Like there's a lot of I don't know, there's a lot of things, right? Destiny showed up. Is that to the Florida one or like what do you mean? To which one? She filed the case in Florida. Yeah. Wait, which date? On which date did Destiny show up to the deposition? Destiny showed up to Pixie's November 3rd? Oh, okay. So she dodged her own deposition on November 3rd, right? Okay, okay. I see. Oh, okay, okay. That makes more sense now. Wait, so Andrew Bretler wanted the deposition for Destiny versus Pixie to be in October in person. Pixie didn't show up to her own fucking deposition on November 3rd, and Destiny did show up. And and after that, now Destiny is threatening retaliatory actions, right? Because because if you didn't show up for your own deposition date, why should I accommodate you in any way, right? Is that the thought process here? Yeah. Okay. Defendant has not demonstrated to his deposition, but her lawyers didn't show up. Wait, are you saying that the date for his deposition has already passed? Wait, her lawyer. Oh, wait, her lawyers didn't show up to his deposition or her deposition? It was 11/6. Oh. Oh shit. So one was on November 3rd and the other one was on November 6th. What? Wait, so did Pixie's lawyers show up on November 3rd, but not Pixie herself? Am I getting this right? So Pixie didn't show up on November 3rd, but her lawyers did. But her lawyers dodged on November 6th. No one from her side showed up? Okay. No. But there has to be a punishment for not showing up to a deposition, right? Destiny scheduled Pixie's deposition for November 3rd. They didn't know. They didn't show? Oh, okay. Wait, a deposition is held in front of the court, right? In front of the judge? In an attorney's office, a court reporter's office, a neutral conference room, or virtually via video conferencing. Oh, attorney's office. Okay, so like in the office. No judge, just court recorder. Oh, okay. It's just what, dude? What an actual like. This is such a stupid case, dude. I feel like this really shouldn't be an issue. This shouldn't be an issue, dude. Like none of this should be an issue. None of the like these are all just fake issues, fake problems. You know my complaint with like Darius always having fake drama and having like fake concerns and fake issues that you shouldn't ever take seriously because it's all shit that he makes up himself. And he exaggerates on purpose for the sake of comedy and shit. Like this is how I feel about it. Like how I feel about it is that this is just legal kayfabe to me. Like to me, this is just legal kayfabe. All of this is just fake, dude. All of this just feels fake. She was too busy with college. Yeah, sure. Destiny says that since you didn't show up to your deposition, fuck you, I won't show up to mine. Sure, yeah. That's fair. Yo, hey, Oh, hey. Yo, yo, yo.
Hi, what's up?